Okay, welcome back to part two of the DOBI Blue Cross Blue Shield webinar. I'm Dr. Brian Capra. We're with Jeff Randolph, and he's going to continue now with the actual process you need to follow for appeals.
Now, one thing that's very, very important is you have to appeal your determinations at least once. So if you're getting a denial based upon this global reimbursement or bundling of E&M or modalities into the CMT, you're going to have to do at least one level of internal appeal. And it's critical that you make sure you're going down the proper route, because if you go down the wrong route, they're going to say that you failed to exhaust your proper appeal processes and that you're dead in the water. There's nothing else you can do. So these are the different categories of appeals or appeal routes that you can follow. The first is medical necessity denials. This is not going to apply too much to this decision because this decision really falls under category 2, which is non-medical necessity denials. The first category is really when you're submitting a treatment plan and you're getting a denial based upon a medical director review saying it's not medically necessary, or they're going to give you less care than you asked for. That's your typical medical necessity denial. Under Category 2, the non-medical necessity denial, this is where the global reimbursement denials fall. So you're most likely going to be following this route. We're going to drill down a little bit in detail on this later. Number 3, the state health benefits plan. Again, that has their own separate route you have to follow. You actually appeal once with the state health benefit plan, which Horizon administers. Then you have to appeal to the State Health Benefits Commission. If you're dissatisfied there, you can appeal to an administrative law judge, and if you're dissatisfied there, you can appeal directly to the appellate division. So it is a separate appeal process you have to file. Number 4 is ERISA. ERISA is a federal law which applies to federal contracts, or if a patient essentially gets a health care plan as a perk for their employment or as part of their employment package, ERISA may apply to that, and they have their own separate appeal process. You're not going to follow this DOBI appeal process we're going to be talking about. And now finally, you may find yourself jumping routes. So you may first get a denial on a claim saying that it's being globally bundled into the CMT. When you appeal it, we've actually seen determinations come back now, not saying that it's globally bundled, but now saying it's not medically necessary. So here you would have initiated your appeal under Route 2, but then based upon their response, you're now jumping over to Route 1, and you have to follow that appeal route. So there is possible jumping in between each route. Okay, these are the exclusions to the DOBI appeal process. Again, like we talked about before, the self-funded plans, such as local unions, they're not subject to this DOBI appeal process. Medicare or Medicare Plus choice products, they're not subject. That's governed by federal law. Health insurance contracts delivered in another state. So some people work for employers who get their health insurance through their employment, and the employer may have a main headquarters in another state, such as California, Texas, wherever. If that insurance contract is considered delivered in that home-based state and not in New Jersey, they're not subject to the jurisdiction of the New Jersey Department of Bank Insurance, and you can't follow their appeal process. Okay. Number 4, PIP and PLIGA cases, that's automobile accident cases, that's not subject to this law. They have their own separate statutory scheme. Same thing with workers' compensation. They have their own set of appeal processes. And then finally, state health benefits plans, like we talked about before, have that different appeal route. Okay, so now you've been denied for an E&M or modality claim because it's been bundled into the CMT by Horizon. What do? We really have to look at those different routes and find out which one am I going to follow right now. If it's medical necessity, if it was clinically denied based upon medical necessity, you're going to take the 3-step internal and external appeal route to an IURO, which is an Independent Utilization Review Organization. And that's called, for short, an IHCAP appeal. That's based upon the name of the statute which governs that. Second route, which is most likely going to be probably 80% of the claims with this global bundling scheme, is going to be your non-medical necessity denial. That's a 2-step appeal process that goes to a major medical arbitration. And that the acronym for that is PICPA, because that is the acronym for the statute that governs that process. This is most likely route you're going to follow if you're getting these global denials. Finally, those non-DOBI appeal routes, if DOBI doesn't have jurisdiction, you may be following a self-funded plan. You may be following the Medicare appeal process, which goes through to an administrative law judge and may go to federal court. The contracts delivered in another state, those states' rules are going to govern. So if you have a patient who got their insurance contract in California, you would have to then look to California's laws to see what is the appeal route. So I know it makes it very hard to do, but if it's issued in another state, you're going to have to follow that state's laws. State and Liga, they have their own appeal route. Same thing with workers' comp and state health benefits.
Jeff, if I could ask a question here, because I know I get it a lot. I've been getting it a lot already. For our clients that are in, and actually, I'm actually one of them. I practice in Northeast New Jersey, so I have a lot of patients with Blue Cross, Empire Blue Cross.
Mm-hmm.
So when they are denying for the same reason, what happens with that?
If it's Empire and it's based out of New York, you're going to have to follow the New York appeals process. And New York has a similar appeal route, but it's not exactly the same as New Jersey. And since this is a determination by the New Jersey Department of Banking and Insurance, it's not binding upon their appeals, although it is very persuasive evidence. So you would have to follow the New York appeal route. And what's supposed to happen is when Empire denies a claim, they're supposed to list clearly in their denial your appeal route that you have to follow. So it's really looking at the EOB that states the denial and then seeing what that says as to, okay, this is your next route of appeal and following that appeal process.
Right. Okay.
Okay, so first we're talking about the non-medical necessity denials, which is basically the one you're probably going to be following. First is the global bundling scheme, which is directly relevant to this situation. Second, if you do get any denials where the explanation says it's outside of your scope of practice, this is the route you're going to follow because that's not a clinical determination. That's a non-medical necessity denial. Same thing with contractual issues. If they say you failed to pre-authorize, if they're saying something's not a covered service, things like that, that would follow this appeal route as well. Same thing with the post-payment audit. Say that you do start getting paid for these E&M modalities. Later on, Horizon comes back and audits you and says, we want the money back. You can appeal that retrospective audit under this process as well. And then finally, usual and customary. So if you're a non-participating provider, you're getting paid less than what you feel your UCR is, you can appeal through this process as well. Okay, we're drilling down a little bit into the IHCAP medical necessity appeal route. So if you do get some either route jumping where you're getting a medical necessity denial after you appeal it, or if you get just a straight medical necessity denial, you have to follow 3 levels, and we just detailed them briefly right here. There's a first internal appeal level, which can be with the carrier's medical director. It doesn't have to be a same specialty provider that looks at it. So it could be a nurse, it could be an MD, DO, it doesn't matter. Level 2, you get an internal appeal again with Horizon Insurance Company. It's with the same company, but they have to have a chiropractor look at your appeal this time. So there is the same specialty requirement at this level. And then finally, if you're still denied at this level, you have the right to go to an IURO, which is the Independent Utilization Review Organization, where you file a $25 fee and you send it to Department of Banking and Insurance. They will then forward the case to this IURO, who will make an independent determination on the claim. And it's critical, this step 3, because this is the first step where you're actually outside of Horizon and you're getting out to an independent company. So most chiropractors are finding that they're winning at this level, even though they're getting denied at level 1 and 2. Okay, jumping over, this is the second route, the non-medical necessity appeal route, which is under PICPA. Now, your first level review is filing this DOBI Form 352, and here we provide you with a link to the website where you can get this application. You can actually fill it out online, save it as a Word document, and it can be sent right into Horizon. And here we have the appeal department address and P.O. box where you would send that appeal to. And then basically, if you get denied at that level, which you most likely will because, again, Horizon is the one who's processing this appeal, and they're most likely going to rubber stamp the denial, you have the right at level 2 to file a major medical arbitration with, it's called Maximus. That's just the name of the company which administers this arbitration process. And the key thing to understand here is if you're participating with Horizon, most participating contracts require you to go to Maximus. You don't have a choice. You can't go to court. You can't go elsewhere. You must go to Maximus. Okay? If you're non-par, you don't have a contract which states that, so you have some more options. And most of the time, I'm recommending to clients that if you're non-par, don't go to Maximus because we're going to talk about the Maximus process and really some of the limitations therein in a couple slides.
Okay, stay tuned and we'll continue with Jeff Randolph and the appeals process.